This is the plaintiff, Robert Reibstein. He says he's a semi-retired attorney who did some work for the defendant, and the guy refuses to pay him their agreed-upon fee. He spent his time and energy working on behalf of the defendant, charged him an hourly rate, and nobody, he repeats, nobody is going to stiff him and get away with it. He demands a judgment against the defendant in the sum of $2,887.50, and that's just what he expects to get today. This is the defendant, Barry Sable. He says the plaintiff does not, he repeats, does not have a signed engagement letter with him. And when you are a so-called attorney, you need to have a signed letter. The agreement they had was based upon a contingency fee, plain and simple. The plaintiff may want to be paid for his time, but that wasn't part of their deal, and he refuses to pay him when he did nothing but waste 9 months of his life. He's accused of having an attitude with an attorney.
All parties, please raise your right hand. Be seated. Come to order. Litigants have been sworn, Your Honor.
Thank you, Douglas. Robert Reibstein?
Correct.
Okay. You are suing Barry Sable for $2,887.50 in attorney's fees. Tell me what's going on.
Well, good day, Your Honor. I hope you won't hold it against me, the fact that I'm an attorney, but I'm Jewish and I can't stand the sight of blood, so I couldn't be a doctor, and my parents made me go to law school then.
Okay.
So, okay.
All right.
Anyway, my area of my practice, I've owned my own firm.
You can't make this
since,
stuff up. Okay.
No way that's scripted.
What kind of law do you practice, sir?
Since 1976 until 2009, I had my own firm doing debtor-creditor relations, and mostly I represented plaintiffs who and businesses that sued their customers who hadn't paid their bills or invoicing. And he stated that he had gotten my name from a client of mine, a previous client of mine, who thought I could help him, and that he needed an attorney to go after 6 judgments which he and his company had, and that they were landlords, and these were tenants who hadn't paid their bills. And I told him that I took cases on an hourly fee. My hourly fee was $275 an hour, but some cases I would take on a contingent fee if I thought it was collectible. And he said, that's what I want. I want a contingent fee attorney.
Okay.
And then the files that he gave me, which I have over here, are extensive. I said, I'm gonna have to review the files for what the other attorneys did previously to make sure I don't duplicate that. And so I need the actual files from you. So we met about 2 weeks later, and he gave me the files, and I looked at the files, and I saw that the other judgments were 7, 6, and 5 years old. So I stated to him, as I told you, there would be costs involved on me doing these searches. That's not my contingent fee. And the cost would be relatively little, and my fees would be relatively little, but that was not doing the collection. It was finding them, seeing if they had any assets.
So what did you discuss with them what the cost would be?
Yes, and
what did you tell them they would be?
Between $125 and $200 per case.
Okay. Did you get that in writing? Did you get a letter of engagement with him specifying that part of it was going to be contingency and part of it was not?
I did, Your Honor.
Okay. Can I see the letter of engagement?
Yes. I met him and took the files and sent him a letter.
Okay, that's not okay. But do you have something? This is a letter you sent him. I know that, and I know I see the dates. I'm just listen to my question. Do you have anything in writing from him? Do you have a retainer agreement with him?
No, because I did not do anything other than the skip tracing and the asset search.
So what? Why wouldn't you? If you want, wait, but you want to get paid for it because you're suing and you're taking up my time, so it's important, right? So why? So, but you didn't get him to sign anything.
I did not need to.
You didn't need to?
No.
Let me ask you a question, counselor.
Yes.
Is it a good idea to do that or a bad idea?
Excellent.
Okay. How long were you a lawyer, or have you been a lawyer?
39 years.
Okay. So do you advise your clients to get stuff in writing, or don't you?
Yes, I do.
Okay. So is the answer to that I didn't need to, or is it, no, Judge, it kind of slipped, I didn't do it? It's not really, I didn't need to,
I didn't
right?
need to, Your Honor.
Because watch this. Did you agree to pay him the fee structure that he's saying? Yes or no?
No.
Okay, so it would be really good if you had that. I'm going to go to everything else now.
My hourly
the letters,
fee.
all that other stuff. It would be really good if you actually had this guy agreeing in writing, because the case would be over in about 42 seconds, right?
That's correct.
So do you want to take back that I didn't need to?
No, I didn't need to, Your Honor.
Oh, you really didn't need to?
I didn't need to.
If I got to waste 20 minutes now, you needed to. Now, let me ask you a question. Did you know that he was charging you a certain amount in order to determine if the case was viable?
No.
Okay. He has a series of letters, though, that he says he sent to you, putting you on notice of how he was going to structure this. And he says that in the phone conversations that you folks had, that he did put you on notice.
No.
So what say you to all the letters?
No. May I respond?
Well, I just asked you, what are you saying to the letters? Do you think you can
Perfect.
respond? Yeah, I guess
Perfect.
so.
I'm going to call this Operation Cirque, okay?
Oh, God,
And if
everybody's
I'm-
an actor.
No, I'm not an actor. I'm not an actor. I'll tell you what it's all about in a minute. Just give me 1 second, please. I would like to break my rebuttal down into 3 categories: engagement letter, contingency concept, and the facts of the case. So if we start with engagement letter, do you have an engagement letter that I
Don't
can
talk
see?
to the litigant.
Your
Speak
Honor,
to
can
me.
I see an engagement letter that he has produced to this court? Because I
No,
don't
but
have an
along those
engagement.
lines, let me ask you the following question.
Mm-hmm.
There's a series of letters that come in September and October, and a series of emails that are sent to you that I see record of in September and October.
Mm-hmm.
Do the content of those letters not state what his fee structure is? Yes or no?
Yes,
Okay.
Did
Do
he-
you have him work after this date? Yes or no?
he did some work, yes.
Right.
But stay
so
with.
why didn't you just say, forget it, you're not the guy for me. That's not how I want to work. I want to work for your
Let me tell you
contingency."
what happened, okay? I get a letter, 10/18. Dear Barry, please review these 5 letters for correctness in content and my spelling and punctuation. Now, in all fairness, for a gentleman
Don't
that...
stare at him down when you're
For
in
a
my
gentleman
courtroom.
that charges
Talk to me.
$275, I have to check his spelling and punctuation. Is this the kind of lawyer that you want to represent you? In a contingency case where there are no upfront fees and you get paid by the definition of contingency upon the reward. So
what'd you have him do between September 3rd, after you got this letter, and October 30th, when you finally emailed him and said, I do not want to throw any more money, I don't want to waste any more money chasing these people, return my
I don't want
files.
to spend because he's on a contingency. Like
Okay,
the guy
honey,
that
you
was
can repeat
before.
that till you're blue in the face. I'm still going to ask my questions, and you have a choice. You could just repeat it and think I'm going to get lost like he did, or we can just dance all day. I don't care. I'm a patient woman. Why did you ask him to keep working on these files between September 3rd and October 30th? And what is it that you asked him to do? Apparently, what you did was you found all 5 people, drafted the letters, sent him the letters for review, but did not mail the letters. Is that accurate?
Correct.
Okay. When he sends you the email on October 30th firing you and saying, he doesn't say, I don't like your fee schedule. He says, I don't want to waste any more money chasing these people. Return my files.
Yes.
Correct?
Correct.
Okay. Why are you suing for an hourly rate when your agreement with him wasn't an hourly rate? The best argument you have is I sent him a letter that he admits to receiving that said this is what I charge. It's not an hourly rate. Your bill that you send to him on September 4th is for a specific amount, which is less than half of what you're suing for here today.
The other part, Your Honor, is I sent him a letter, which I believe you have, dated October 18th. And that letter said, hey, I haven't gotten the $750, and it's $600 if you want me to take the files. That's just a retainer. And please send me that money and the cost to do a search on a real estate abstract, and I will continue. He called me.
So what are you really out? What you're really out is the 750 plus the 600?
$750. Correct, Your Honor.
Wait, but not the 600, just the 750?
I'm at the 600 because he told me, he put the checks in the mail to me, and that go ahead and send out these letters, which I did.
And that was in a phone call?
Yeah.
So you did send out the letters?
But yes, and I confirmed that in my writing.
Do you have, let me see the writing. In a letter to him, you mean?
Yeah.
No, this says, please review these 5 letters for correctness in content and my spelling and punctuation. Let me just, as a word of advice, I know you have 39 years experience. No client wants to check your spelling and punctuation.
I didn't have a
They kind of
secretary.
figure you have that.
I didn't have a secretary.
It doesn't matter. Check your own spelling and punctuation. No, that doesn't instill confidence in a client. Call me as soon as you are through so I can get them in the mail by tomorrow noon. Right, but so did you hear back from him, or you didn't hear back from him with corrections and whatever else?
Oh, I did hear back from him.
And did he correct anything?
No, he didn't need the corrections. He said the letters were fine.
And to mail them out.
And he called me back on October 25th and said, send the letters out.
Okay, do you have that phone call? Do you have your phone records from October 25th?
No, Your Honor, I don't. However,
that would be good too, though, right? Like if I could see all the activity and telephone between you guys in October, that'd be awesome.
I didn't feel that phone records showed that there were phone calls, Your Honor. I believe that what was said on the phone calls. But, Your Honor, I did say that.
He denies that he told you to send the letters, right? You deny that.
Okay.
Yes.
Your Honor.
Did you ever hire subsequent attorneys to handle this after him?
No, because he has my files. He won't give me back my files. Your Honor, can I just make one point that's really important here? I mean, to me,
asked for those files, Your Honor.
Stop.
This to me is a 42-second knockout. He has no retainer letter with a signed agreement from me. And the second thing, Your Honor, is Rule 15C requires that all contingent fee agreements be reduced to writing and signed by the client.
Did you see the letters he wanted to send?
He sent me letters and I didn't give him permission to excuse me. That's
Okay, don't talk to each other again.
But that's rude. Here's a lawyer that doesn't even know law. If he can't spell and punctuate, he's surely not going to know the canons of law.
Okay.
But besides that, let me tell you something. I'll make it real simple for him. He spent all of this time. If somebody clerically could go collect, let him go collect now. Let him go collect now. Charge the 25%. He has no expenses. Let me finish.
No, I'm not going to let you finish because I'm sick of hearing you.
Welcome back to the People's Court. Harvey Levin here. So does this guy have to pay the lawyer?
Of course he does. It's ridiculous.
Well, there was no retainer agreement, but...
It doesn't matter. It's part of the deal.
Well, the deal is the guy keeps getting bills every month. Does he have to pay even if there's no retainer agreement?
I think he does need.
Why?
Because he accepted the work. He accepted the work from the lawyer, and
I think the words accepted the work begins and ends this whole thing. Going inside the courtroom.
Let me explain to you fellas something that's very, very simple. It's very, very simple. When someone sends you a bill, okay, and you say nothing and ask them to continue working, you are in essence implicitly agreeing to the fee structure that he has named. It's $1,000-something. It's not 20. I don't want the sound of your. No. I don't want to hear the sound of your voice again. We're done. Okay. But when somebody tells you, I'm going to charge you X, if you don't want to pay it, don't continue to employ them. But you can't continue to employ them and then say that wasn't our agreement, because it becomes your agreement when you ask them to keep working after that. Okay. All right. I find in favor of the plaintiff in the amount of the original bill, not this hourly rate that you're talking about, for $1,350. That is my judgment.
Thank you, Your Honor.
So there's a defendant coming out of the courtroom. You're still talking to him even after the case is over. What are you saying to him in there?
This is preposterous. He didn't do any of that work. So therefore, the judge didn't give me an opportunity to explain.
Well, how glad are you to have him out of your life for good?
Well, as long as I get my files back, why would I need him? He can't spell or punctuate. Why would I need his services?
All right, okay. Right around the corner, documents waiting for you right this way. Okay, so now the plaintiff comes out here. Step right over here next to me and tell me, you satisfied how this comes out finally?
Yes, but I think that we ought to know that the reason that I asked to help him with my punctuation, I didn't have a chance to proofread them. He wanted them done right away, so I sent him.
You finally agree with the judge that it's better to have a written agreement signed by both parties? Finally agree with that?
Oh, absolutely. But
Harvey?
Okay, let me just say, in spite of the fact that the plaintiff won this case, it is ridiculous that he didn't get a retainer agreement. That will do it for this case. Litigants for the next case on the way into the courtroom right now.